I'd like to begin with a very simple question to Mr. Smith. We're here today discussing law enforcement access to data stored abroad. Why is it important for Congress to act on this issue? What are the dangers if we simply leave things as they are?
Well, Senator Hatch, it's an important question, and I think the short answer is the status quo leaves us all hostage to a law that was passed 31 years ago that hinders law enforcement, undermines privacy rights, and frankly puts tension between countries when law enforcement tries to act across borders under the current regime.
As you know, the Department of Justice has called for a, quote, clean reversal, unquote, of the Microsoft decision. Now, this would give law enforcement the ability to compel disclosure of electronic data held by U.S. providers like Microsoft, no matter where the data is stored. Why, in your view, is a clean reversal of the Microsoft decision not the right response? And what unwelcome consequences would such an approach produce?
A, quote, clean reversal would literally take us back to a law that was passed when Mark Zuckerberg was 2 years old. It would create the very risk of conflict of laws that I described in my oral testimony, especially when we look at the General Data Protection Regulation taking effect in Europe next year. It will create conflicts of laws and put tech companies in the middle, and I think leave both law enforcement unsatisfied as well as those who care about privacy rights.
Well, you also know that last Congress I introduced the International Communications Privacy Act, or ICPA, to create a clear legal framework to U.S. law enforcement requests for electronic information stored abroad. Now, as I've said, I plan to reintroduce this critical legislation in the near future. Among other things, ICPA would require the United States to provide notice to foreign countries that meet certain conditions, such as having a law enforcement cooperation agreement with the United States when seeking electronic data belonging to a national of that country. Why is it important to provide for such notice, and how does providing notice assist our cooperation efforts with other countries, and why is providing notice important for U.S. companies like Microsoft that do business overseas?
I think notice is very important in two respects. First, when you think about it, it is critical for our ability as a technology sector to assure customers in especially allied and friendly nations that they can trust American products.
Right.
The quintessential question typically is put to us by, say, somebody who works for a public authority in another country, and they're very worried about the possibility that the U.S. government could access their data without their government or their court even knowing about it or their rights being addressed. And then the second is simply think about what happens when the shoe is on the other foot. The United States does not expect or even tolerate that from other governments. We've objected, ICPA itself bars it, and we as a company at Microsoft, we've paid a fine, or we're contesting a fine of over $30 million to the Brazilian government because they have been demanding that we turn over data in the United States, and U.S. law would not enable us to do so. So as Professor Daskal said, a sense of reciprocity and even just fair-mindedness basically requires that we do what we ask others to do.
Well, as you also know, ICPA would also require U.S. law enforcement to obtain a warrant to access the content of electronic communications, regardless of the age of the communications. Why, in your view, is mandating a warrant for content for all electronic communications important? In particular, let me ask you this too. Why is it important in the international context when U.S. law enforcement is seeking data from U.S. providers stored overseas?
Well, I would first say, look, we appreciate that is a distinct issue from the issues that are before this legislation. But I think as a company and as an industry, we've been broadly supportive of requiring warrants for content. Simply think about two things: a document that sits on a piece of paper on your desk and a document that sits not on a piece of paper, but in a data file on a hard disk in a data center. You clearly need a warrant for the first. Shouldn't you also need a warrant for the second in the 21st century? I think that's what we hear people expecting of us and of the government.
Thank you, Mr. Chairman, for convening this really important hearing. I've been concerned about the issue of law enforcement access to data stored abroad for quite some time. I first introduced legislation on this topic 3 years ago after conversations with a number of tech companies made clear to me that U.S. law enforcement demands for data stored overseas, coupled with conflicting data privacy laws in other countries, were increasingly placing electronic service providers in extremely difficult situations. The result of these discussions was the International Communications Privacy Act, or ICPA, which I introduced with Senator Coons. ICPA creates a clear legal framework for determining when U.S. law enforcement may compel service providers based in the United States to turn over data that is stored abroad. I spoke yesterday on the Senate floor about ICPA and my plans to reintroduce an updated version of this legislation in the near future. My updated bill incorporates feedback from both law enforcement and privacy groups and is grounded on three principles: respect for other countries and their laws, international comity, and reciprocity. ICPA is one of my top priorities, and I plan to push very hard for it once it's reintroduced. I ask unanimous consent, Mr. Chairman, to place into the record a letter from ACT, the app association, describing the pressing need for this legislation. Now, for some questions that I'd just like to ask before we finish here, for Mr. Wegman, in your written testimony, you acknowledge the existence of conflict of law problems in cases where a foreign government seeks to compel data from a U.S. provider, and disclosure would violate U.S. law. At the same time, however, you downplay the possibility of conflict of laws problems in cases when U.S. law enforcement seeks to compel data from a U.S. provider, and disclosure would violate foreign law. How do you reconcile these two positions if the dilemma that providers face when foreign law enforcement orders disclosure in violation of U.S. privacy laws mandates congressional action? Why doesn't the dilemma that providers face when U.S. law enforcement orders disclosure in violation of foreign privacy laws similarly mandate congressional action? Isn't there a double standard there?
No, so thank you for that question, and again, thank you for your leadership on this issue. Really appreciate the efforts that you've made to come up with legislation that that will be acceptable to all parties in this effort. We certainly didn't mean in our testimony to downplay the potential for conflicts when U.S. authorities are seeking data overseas. That potential exists. We have just not seen it in the same scale as we have in the reverse. Just so, for example, in the Microsoft case itself, we were seeking data in Ireland. We were not notified, and Ireland did not take the position that there was any conflict between Irish law and the U.S. Execution of the warrant. The same is true in all four of the other cases that we've litigated since then, where we have, where the courts have held that we do have the authority to get access to data stored overseas. In none of those cases did the companies identify a conflict between the U.S. warrant and foreign law. And in fact, the companies had been complying with U.S. warrants on a regular basis before the Second Circuit's decision without having problems with conflicts. But putting all that to the side, the potential for such conflicts certainly exists. We don't deny that. There could be foreign governments that have blocking statutes. And if they do, there are a few things that we would do. One is we would try to see if we could come to some accommodation with the foreign government, evaluate what their interests are, see if there's a workaround that we could do where we could meet U.S. needs and meet foreign government needs. If we can't find the workaround, we might be obliged to use an MLAT or do something like that. If that doesn't work, we might have to seek to compel compliance with the order. But even then, the court is going to evaluate the comity factors that you were just mentioning, which is we would go into court and say, we really need this investigation to investigate this sexual abuser or this terrorist. And the court would have to evaluate and weigh the U.S. interests against the foreign interests of the foreign government in blocking that. So we're not saying we have an absolute right any more than a foreign government would, but we want to have the authority to seek the data the same way that many other governments do, ranging from Canada, Mexico, Belgium, Brazil, our friends in the United Kingdom who have full authority to assert data overseas. We just want the same authority to put us back in the same position as our friends.
In your testimony, you advocate for a, quote, clean reversal, unquote, of the Microsoft case, by which I take it you mean giving U.S. law enforcement authority to compel disclosure of electronic data held by U.S. providers regardless of where the data is stored. How do you respond to concerns that I and others have raised that this state of affairs would put providers in extremely difficult positions in cases where foreign law prohibits the very disclosure U.S. law enforcement is seeking to compel. What are providers supposed to do when faced with a U.S. court order requiring disclosure and a foreign law prohibiting disclosure? Whose law do they violate? And I know I'm going over a little bit here. Which employee do they send to jail? I mean, these are questions that I'm concerned about.
Well, as I was just trying to explain, there is a potential for such conflicts. In the majority of cases, we have not seen such conflicts when the shoe is on the other foot. But if those conflicts do emerge, we would work with the companies. We would work through the court system. There are factors that a court would consider in determining whether to enforce an order. And so the bottom line is we would try to work it out. But to be clear, this whole US-UK framework that we are proposing is an effort to resolve just the question that you're raising, Senator Hatch, which is to create a mechanism whereby we can avoid these conflicts, bring down barriers to rights-respecting countries being able to apply their law to get data access overseas. But in order to make the framework work, we have to have the same authority on our end that the UK has on their end, and we don't have that authority unless we reverse the Second Circuit decision.
My time is up, Mr. Chairman. I wouldn't mind asking one more question if I can. All right. Let me give you an example of the sorts of conflicts of law problems U.S. companies are currently facing. 2014, Brazil passed a law that, among other things, prohibits the disclosure of data about Brazilian users to governments other than Brazil. If U.S. law enforcement compels a cloud provider to disclose the emails of a Brazilian suspect, doesn't that create a conflict of laws for that provider?
It could. It's possible that if other states, again, have blocking statutes, then if they do have those blocking statutes, then there would be a conflict of laws, and that's when we would have to try to, work out what the appropriate resolution is. And there's law in U.S. courts. We confront the situation, for example, with bank secrecy laws. We have the ability to go after bank accounts. Some countries have bank secrecy requirements, and the courts have doctrines that they use to apply essentially comity factors, where they consider the relevant interests of the two countries and weigh those interests against each other in determining whether enforcement is appropriate. Okay, and that's what we would submit as appropriate here.
My staff met recently with you and several of your colleagues to discuss the International Communications Privacy Act. And I'd like to work with the department to continue to refine the bill and to ensure that it creates a workable framework for law enforcement access to electronic data. Will you commit to continue working with me and my staff and others on this committee in this effort?
Absolutely.
Well, we appreciate it. Appreciate your testimony today.